Preston, you had met with the survivors after court had recessed. Can you give us just an idea of what your sentiment was and what message you shared with them?
So what I shared with them, first and foremost, is my frustration with this process. In the state of Washington, we're in a situation where defendants' rights and the focus is so defendant-centric that crime victims are left outside. And so that's one of my frustrations with this. I also voiced my frustrations with this process. I shared some of the same anger that they had about the notification process. It really highlights, in my opinion, a need to reform RCW 7109, which is our sexually violent predator statute, and specifically to reform some of the criteria for a person to get this type of a release. There is no requirement once somebody doesn't meet one of the prongs that they ever were repentant or penitent. So in this situation, he's released without ever having acknowledged his guilt, without ever having completed treatment, without ever having provided or made any request for mercy. I had some words to them regarding moving forward. We heard a lot in there about anger, frustration, forgiveness. This is a situation that Mr. Coe, I personally believe, unless he changes his ways, will face a judge that transcends this court's jurisdiction. And ultimately, he will, unless he changes his ways, spend eternity surrounded by flames and surrounded by the maggots that eat him, not dying. And that might be the just result in this case. However, while we are here, the laws that we have available to us, and it's RCW 7109-090, that's the section that applied in this case. What I told those family and survivors in there is that under that iteration of the law, Judge McKay had no option but to do what she did. The court had no option once that criteria is not met according to that statute. And frankly, the Attorney General's office had no option once that expert witness made that opinion. So when I became aware that this is what was happening on this date, I tasked a team of 5 lawyers to review all of the evidence, to review all of the experts, to interview the last expert. We did an interview with my team and an investigator to determine, is there any avenue under the existing statute where we could still proceed? Unfortunately, in speaking with that expert and in speaking with the senior attorneys that reviewed it all, the way the statute's written right now required the result that we have. So the Attorney General's office followed the law, and the law is what we have written. That doesn't mean that that's how it has to be, though. We could change that. There can be some reform that I think would elevate victims' rights and that would allow their voices to be better heard. And so that was the message that I had for them in there, that we are very attentive to that, and that if there is a desire or appetite for reform, we will be first and foremost in addressing those concerns with our legislators.
And Preston, what is your perspective on the impact this ruling had today on the Spokane community?
The legacy that Coe has left on this community is a dark one. The frustration that I have when somebody who's such a prolific offender is released is that it leaves everybody wondering why. It leaves them wondering, why do we go through this process? Why do we spend hundreds of thousands and tens of millions of dollars prosecuting somebody, incarcerating them, and then only to have them released at the end? So I think the impact is one of frustration and confusion, but I also am hopeful that through cases like this, that the public sees what these laws actually result in. And so this is a circumstance where somebody and the public is going to be able to see the entire life cycle of this case, of the sexually violent predator statute. It's a good statute, it's a good law that allows for protections when the criminal statutes aren't sufficient to capture the conduct that's there. And so this is an opportunity for the community to see how that plays out, and it's an opportunity for them to weigh in and say, we could do better, we want to do better.
How did the survivors react or respond to your comments after the hearing today?
They're frustrated, and rightfully so. And they get to be. We are in an imperfect system where they do not have the protections that, in my opinion, they're entitled to. So our society, our our values need to be more focused on those that are affected by crime versus every single story, every single bill that's going forward. Instead of venerating the criminal, we need to be talking about the impact that that criminal has on our local community, because every single case that gets filed in this courthouse, every criminal case has a crime victim at the other end of that. And so that is where the focus needs to be versus venerating and elevating criminals in our society.
You mentioned the notification process and your frustration with that. Can you just specify what frustrations with the notification process you had?
Just the timeline in terms of when my office became notified, when victims became notified, whether or not the police department was notified. Those are all concerns that I have. And that's an area where, we could draft a law and throw something out there, but sometimes those details are forgotten. Where say, hey, when am I going to let somebody know? How am I going to let somebody know? When we let them know, is it going to come through a writing, a press release, a phone call, or are they going to go meet somebody with a victim advocate and say, hey, there's been a change. Let's talk about that change. So I think there's opportunities for improvement all the way around, and those particular details aren't fully baked into the statute. The statute might read plainly, you'll provide a notification, but it doesn't really lay out the format and fashion of that.
The Superior Court office sent out a press release saying that there could be a potential, as far as next steps, that this case could be revisited. Could you give context to that?
So one of the questions I had for the Attorney General's office, because I was, again, extremely frustrated, first to learn about this, and frankly, I was mad at the Attorney General's office. I thought that there's more that they can do. But once I delved into RCW 7109, it became clear to me that their hands were tied based on the evidence and information that they had. And so, but that is true. One of the questions I had was, in the event of a future occurrence, say his health gets better, there is an act of predatory violence, what are you going to do about it? And they said that they have the opportunity to refile, and that if those facts present themselves, they will. That they'll be watching this, keeping eyes on him, and that if there were to be some change, they could bring a new petition.
Is that something where the survivors would have to relive this? I mean, as part of that process, would they have to relive this all over again?
Unfortunately, we're stuck with what the law allows now. So they would have to go back through that RCW 71 process. My understanding in asking the Attorney General's office is that they would be allowed to rely on the filings that occurred under this cause number, but a new action would happen under a new cause number. And so, yes, that brings up one of the issues we talked about, is in the state of Washington in particular, there's no finality in a case. When somebody gets a conviction and they walk out of one of these courtrooms and a jury has found them guilty, my office spends the rest of either their lives or the rest of whatever attorney's lives are in our appellate unit consistently protecting that conviction. So every time there's a change, every time there's an appeal, every time there's a personal restraint petition, we have to reach out and notify crime victims, hey, they're taking another crack at this, and a team of judges at the appellate level could overturn what a jury found.
Preston,
And so,
sorry to kind of double back a little bit, but you, one of the survivors mentioned a defense attorney's conduct towards the judge or something in this case a couple months ago. Are you able to expand on what happened that day, or do you?
so I can't speak to that because I was not present for that hearing.
Okay.
Today, when, McKay, obviously, she allowed the victim impact statements, obviously very clearly saying this will play no effect in what's going to happen. I mean, seeing a judge, especially in Spokane County Courthouse, taking that and allowing that to happen, how did it feel as, the prosecutor that oversees this courthouse?
I was proud of how the court handled itself. And so even though it couldn't have an impact on the outcome because both parties were moving or joining in that dismissal, I believe Judge McKay showed that she honored the crime victims by allowing them to speak, which is consistent with Article 1, Section 35 of our state constitution and with RCW 769. It requires that judges, prosecutors, and law enforcement protect the rights of victims. And so notwithstanding a provision in 7109 about victims speaking, Judge McKay honored the crime victims in this case by permitting them to speak. So I think that speaks volumes about the caliber of judge that you have handling this matter.
And Preston, frustration is something that you've used to describe today for yourself, and it sounds like the other agencies and offices involved. What can we expect that frustration to formulate into going forward?
Advocacy. Advocacy in changing statutes for the better, Advocacy moving forward when we're discussing legislation that impacts crime victims, that impacts offender sentences. And so that is an area that I believe very strongly about, and it's cases like this that are waking people up to what the impact of their laws actually are.
For the public, I think the biggest question is, what happens with Mr. Coe now? Where is he going? Will he truly be walking free, or will there be tabs on him?
So that is going to be a question better postured to the Attorney General's office. I asked the same thing. My understanding is that he's going to be released to a facility somewhere on the west side, but there are no restrictions. I asked, is he able to just walk out if he's able to? And the answer was yes. So unconditional release under this statute truly means unconditional release. My hope is that there will be eyes on him. I know that I've indicated to the Attorney General's office and I've indicated to our local Spokane Police Department that this is a case that we'll be inquiring about to ask what's the status update to the extent we're able to get information. So this is something we feel very strongly about and we'll continue to ask questions.
Thank you.
Thank you.
you.
Thank you very much.
Appreciate it.
Appreciate it, Preston.
Yeah.
Sorry about.
This is one of the most frustrating